Tonight, it is all about the law. We will start with the Supreme Court and how it is dealing with the president's executive action when it comes to immigration and deportation. So the question is, can the High Court limit presidential authority? Then, ESPN just canned Curt Schilling. The baseball analyst posted a controversial tweet here and photo attached about the transgender community on social media. But the question is, even if he is an unsympathetic character, where does the line start and stop when it comes to free speech and employment? Then, suing the Saudis. Congress working on a bill that would let the families of 9/11 victims sue the Saudi government. But would that lead to all sorts of unintended consequences for Americans? We'll debate all those stories and a lot more with our panel of attorneys. Evening, everybody, and welcome to RFL. Thank you so much for joining us. I am Richard French, and we begin tonight with the High Court. Supreme Court has a human face, and that face is a 6-year-old girl who is pleading with the High Court to let her family stay together and stay in America. Here is Sophia Cruz.
I have the rights to protection. I have the rights to live with my parents. I have the rights to live without fear. I have the rights to be happy. Give me the opportunity to achieve my goals.
Her family, as you can tell, supporting President Obama's executive order that would have stopped the deportation of millions of undocumented immigrants. And after the president ordered it, 26 states sued to block it. That case now before the Supreme Court, and it could face a 4-4 deadlock. And it opens up a bunch of questions about presidential power and the power of the courts to regulate it. Let's bring in our panel to weigh in. Richard Brodsky, attorney, former Democratic New York State Assemblyman, and to his left, Thomas McDonald. He's a law professor at Pace University specializing in international and immigration law. Mayo Bartlett, an attorney at the law offices of Mayo Bartlett PLLC, and he's a former chief of the Bias Crimes Unit at the Westchester County DA's office. And Bill Aronwald, defense attorney and a former assistant U.S. attorney. Guys, thank you very much. And, you know, I start with you, Tom, and as it relates with immigration, where is the line start and stop with what the president can do and what the states can do in terms of saying, nice try here, but we'll do our own way?
Well, that really is the question. I think there's agreement that the president has the authority to decide not to remove a certain number of people. The real issue in this case is whether or not he also has the authority to grant work authorization and ancillary benefits. One deals with prosecutorial discretion, which I think, although there's some people who have argued that he's overdid his prosecutorial discretion, but I think the real issue is, can he authorize work authorization? Work authorization has been authorized in cases of deferred action, which is what this plan is, at least as under regulations.
Put it in layman terms for our audience, work authorization. What's the crux that the
Well, what
court's
that
gotta wrestle
means
with?
is that normally if a person comes here without inspection or is otherwise overstays his or her visa, that person does not have the right to work legally in the United States. If you get work authorization, you have the right to work legally in the United States. And that's really the tough question, because that does seem to perhaps go beyond what presidential authority might be. It's not necessarily just withholding removal of that individual. But on the other hand, there has been longstanding precedent for presidents to do so. In fact, President Reagan and President George H. Walker Bush, essentially when they had their amnesty program, authorized some 1.5 million individuals who were spouses of individuals who qualified for amnesty and children of individuals who qualified for amnesty, but they themselves did not qualify for amnesty. So there is precedent for what President Obama has done. Nonetheless, it does have the appearance, of perhaps exceeding presidential authority.
Bill, you agree? And also, if it is a deadlock, like many cases seemingly may be going forward at 4-4, what's the net result?
The net result is that the cases from which the appeal is taken, the law in that case stands. And that's really where the Supreme Court is heading, unless the Republican in Congress decide to exercise their constitutional responsibility to give these nominees of the president fair hearing and give them an up and down vote. But right now, Supreme Court is paralyzed because all of these hot button issues are going to wind up generally being split 4-4.
And do you see any way they split the baby here and that the court can reach a majority decision and make some kind of clarity in terms of how far the president can and can't go?
Well, during the argument, Chief Justice Roberts, asked a question which struck people as somewhat odd. He asked whether or not the executive orders could be legitimatized if some of the language was excised out of it. And that basically goes beyond what the Supreme Court really has the authority to do. And so what it's doing is it's sort of trying to salvage it, maybe cut the baby in half, but the only way they could do that is by removing some of the objectionable language, which I don't think would satisfy.
I was going to say, how does that work? How exactly do you say, let me get an eraser here and let's read?
Well, that's why his comments struck people as odd. But to his credit, I think what he's trying to do is he's trying to address the fact that the Supreme Court cannot function and do its job as long as you have an even number of justices.
Well, to that point here, the question, the broader one, is about how limited the court is right now at 4-4, and we'll get into, whether or not we'll see a ninth justice and when, but also overall, is the Supreme Court too politicized? And if it is, who do we blame for that? Chief Justice Roberts, the aforementioned justice, he blames the Senate directly. And he recently wrote the following, quote, "The process is not functioning very well. Look at my more recent colleagues, all extremely well qualified for the court, and the votes were, I think, strictly on party lines for the last 3 of them or close to it. That doesn't make any sense. That suggests to me that the process is being used for something other than ensuring the qualifications of the nominees." But not surprisingly, one senator, and in fact, the head of the Judiciary Committee, Republican Senator Charles Grassley, he has a different take on it. He has this response directly to Justice Roberts. Quote, "The Chief Justice has it exactly backwards. The confirmation process doesn't make the justices appear political. The confirmation process has gotten political precisely because the court has drifted from the constitutional text and rendered decisions based instead on policy preferences." Mayo, is it the whole debate is to, in the late Scalia, I'm a strict constructionist, it's just as how it's written and don't go outside the 4 corners, or interpretation, or is it something much different that we're debating now about the court and the politics with it?
I think you can look at all 3 branches of government, and every branch of government either overreaches or else you find a willingness not to fulfill their duty. And when you look at Congress, the suggestion that you're not going to give an up or down vote to someone who has unanimously been seen as qualified for the Supreme Court, it's saying that we're not going to perform our sworn duty. The president quite often, and not just President Obama, presidents throughout recent history have quite often gone beyond what their mandate is under the law as an executive. And when you look at the judiciary, the same thing happens, and you can go back to the 2000 election.
Richard, is it a little Pollyannish of us to think, oh my God, in this day and age, how politicized we're making not only the confirmation process, but the court itself? FDR, God love him, tried to stack the court. I remember the Bork proceedings here. Is it just depending on where you sit that it seems politicized, or has it really gotten a lot worse in recent years?
There has been a historical sense that you vote for qualified people, even if you don't agree with their ideology. That's been the system for X number of years. That's not always been the system. There's nothing constitutionally offensive for a senator to say, I'm not going to vote for that guy because I disagree with him on abortion. I'm not offended by that. But at a certain point, when you get to the institutional function, you've got to make a decision that goes beyond the policy fight and lets the democratic process, the constitutional process, function. I thought the analysis we heard here was quite good. There's a lot of precedent for what Obama did.
He doesn't say that often, by the way, unless he's saying it, but go ahead.
It doesn't happen often. There's an enormous amount of precedent where Republican presidents did largely what Obama's done. The 26 states that brought this case are largely Republican. The fight about abortion is going to be settled first in the presidential race, and then it's going to bounce back to the Supreme Court.
Deportation.
In the end, we're going to get a 4-4 decision. There's not going to be any written opinion of the court. We're going to be back to going, who knows?
The difference here, though, Richard, is that we're not even talking about the qualifications of the actual individual. We have declarations before any nominee is even set forth that the Republicans are not going to even give that person a hearing.
Is there an hypocrisy, though, for the Democrats? We all go back to what Joe Biden said in the 90s, where he said pretty much the same thing, that, hey, we should wait till the next president.
Absolutely, and it was wrong then, it's wrong now, and it will be wrong whoever does it in the future. And it's really hurting the American people when you do that.
Take a look at the nominee, Justice Garland, okay?
Yeah.
He's already been confirmed by the Senate. to be a federal judge, be a circuit court judge.
And
What-
Grassley, it was on record, but what he was confirmed prior is that he was a fantastic justice.
What's changed?
Yeah.
Nothing has changed.
I don't know. Well, the Supreme Court has changed. He was confirmed as an appellate, a circuit appellate judge, not on the Supreme Court. I think these guys are abusing their power. I agree with the panel. But I don't think it's nutty to say, what's nutty would be for not giving him a vote, but it wouldn't be nutty to turn him down.
But that's what they're talking about, not giving a
Don't
vote.
raise your hand, just jump in.
I agree with Richard on this, and I agree with Mayo. There ought to be a vote up and down. And if you disagree with them, vote them down. And I think if we had a vote today, there would be a vote down. And I think, with all due respect, Bill, there is something different. Scalia, okay, was the 5th vote for the conservatives. This is going to change if Garland gets on the court. This is going to change the makeup of the court. We have to admit, the court is extraordinarily powerful. When the court rules on a constitutional issue, it essentially cannot be reversed. Okay? It cannot. The amendment process is so difficult that when the court rules on a constitutional issue, that's the law. And so although the thing is, I was not a fan of Justice Scalia, and I would rather see a liberal justice appointed, I think we have to recognize this is a political process. If the situation were reversed, if the Democrats were in power, the same thing would have happened.
But here's the question
Perhaps
that I
with
have.
allowing a vote.
But here's the question that I have. Let me bring Bork back up. Nobody disagreed the guy was brilliant, okay? Now, I had a lot of problems with some of his writings, but it always struck me the thing that made Bork uncomfortable for some was that actually he was transparent. The farce that goes on with these confirmation hearings, you're trying to find somebody who's never given an opinion on anything that you can pin on him. So then they go sit in the meetings, the one-on-one meetings, when they go through the tour of the different offices for the Justice Committee and the rest. They nod approvingly, say nothing. President probably gets them and say, listen, if I put you on here, I don't want another Kennedy on my hands where I think I'm getting something else. Right? Through surrogates, they're going to try and get an idea as to what they're going to get. At the end of the day, we go through something. Should our only qualification be that they're very competent, that they are very learned, or should their politics, of course, matter? Should that matter if they're going to be the swing vote?
What's your answer as the non-lawyer?
I think it's a little bit of both. I take issue where people think that the person has to have worn a robe before in their life. I think it would add something if Mario Cuomo, for example, right? Actually, didn't vacillate like he did on everything and actually decided that he wanted to take the nomination when Bill Clinton offered it, if in fact it's true. It would have been a different voice on it.
In the end, you could be right or wrong. It's an interesting and important point. But the thing that I think we have unanimity on
he deserves a vote.
You give him a vote, and if you want to take the political heat of voting no, take the political.
Okay. On this next one, guys, we get to give Richard a hard time, and I've looked forward to it all day. When we come back, Shelley Silver. He's apologizing for what he did. But the question is, the prosecutors are saying not good enough here. They're pushing for him to spend real time, more than a decade in prison. Will the court show him mercy? And more importantly, should they?